Today, we dive into a tense moment on Capitol Hill, where former Trump administration official Kash Patel faced pointed questioning from Congressman Dan Goldman of New York during a hearing that has quickly become the subject of national attention.
Gentleman yields back. The gentleman from New York is recognized. Mr. Goldman.
Mr. Patel, does Donald Trump appear anywhere in the Epstein files?
I'm sorry, could you say that again?
It's not a complicated question. Does Donald Trump appear anywhere in the Epstein files?
I didn't say it was a complicated question. I just didn't hear you, so my apologies. We have released where President Trump's name's in the Epstein files and everybody else, and all credible information that we are legally allowed to release has been released.
All right, so let's go through that. You're referring to court orders that prohibit you from releasing grand jury testimony under Rule 6E. Is that what you're referring to when you say as the law allows?
That's a piece of it.
Really? What other evidence do those three court orders you cited prohibit from being released?
Information that was collected pursuant to those search warrants that were limited in fashion.
Wrong. That's not what the court order says, and that's not under 6E.
And you're talking, and I said that's 6E, and I said there was others, and I'm answering that. There are sealed court order documents. There are protective orders.
They are unsealed as part of discovery given to Ghislaine Maxwell. They are no longer sealed.
That's just not true. We can argue about it all you want.
Okay, well, you agree that there are, so your testimony here is that the reason why you are not releasing all of the videos that you have acknowledged, there are so many, and that the FBI spent thousands of hours of reviewing, the photographs, the photographs that you have. You're saying that you're not releasing those because there's a court order requiring them to be sealed? Is that your testimony?
Never said that about the videos. On the totality of the videos, of the thousands of images that were seized pursuant to the search warrants executed at the time, the overwhelming majority of that video is pornographic material that was downloaded from the internet and child sexual abuse material. We will never release that.
Well, as you should not release the victims. But if there are videos that relate to others who Epstein trafficked to, such as maybe Prince Andrew, or photographs, that you have total control to release.
Yes, and if it exists.
And so why haven't you released it?
Why are you supposing that that is a fact when in fact it is false? Are you saying that
you're saying that none of the videos relate to anything relevant to the Jeffrey Epstein trafficking ring?
Every single video that we have collected pursuant to the prior search warrants has been examined for the last 10 years. And every single video has been utilized for whatever prosecutions were able to be legally brought.
I'm not asking about prosecutions. I'm asking about why you aren't releasing the full Epstein files, including the names of people who were involved in the sex ring that you promised to do before you became FBI director.
I just told you, I'm not going to release downloaded porn of
I'm not asking about that. Fine. I'm asking about all the other files.
What other videos? Tell me. Tell me.
That's what I'm asking.
Tell me.
You're saying there are no videos that would be relevant to anyone else involved in the Jeffrey Epstein sex ring.
Pursuant to Mr. Acosta's collection of information based on the search warrants. That's all we have in our possession.
And I'm asking you, that stuff.
That's all we got.
I'm not asking all you got. I'm asking you, in that stuff, there's nothing that's related to any other sex traffic, any other people engaged with Epstein in underage sex.
That's correct. To my knowledge, no.
Okay. Let's talk about the witness interviews. 302s of witness interviews. Those are not subject to the court order. Those are not subject to any fictional sealed order for a search warrant. Why aren't you releasing those with the redacted names of the victims?
We are releasing as much as legally allowed. That's why we went back to the courts.
How is that not legally allowed?
Sir, do you know how court orders work? Do you know how protective orders work?
Actually, Mr. Patel, I was a real prosecutor for 10 years. I know exactly how.
So I was a fake one?
And I want to understand what the court order prevents you from releasing witness statements that the FBI took.
You should know that as a real prosecutor, when the court hand downs a protective order and a motion to seal, the material is sealed unless that judge waives it. Your testimony here
is that all of those witness statements are under a court order, a protective order.
We are providing everything we can legally provide.
No, that's not my question. My question is, why are those witness statements that are not grand jury testimony, that if they were under a protective order are no longer under a protective order, why are they not being released?
How are they not under a protective
Why
order?
are you not going to the court like you did for the grand jury testimony to unseal those records?
The DOJ did go to the court.
No, not on those records. Why aren't you going? You just went on grand jury.
Time of the gentleman has expired.
You are hiding the Epstein files, Mr.
Time of the
Patel.
gentleman has expired.
You are part of the cover-up.
Can I respond?
You sure can.
Any allegations that I'm a part of a cover-up to protect child sexual trafficking and victims of human trafficking and sexual crimes is patently and categorically false in the work of my
So I hope you will talk to them when they have requested to speak with you. Because the victims have requested and you are not responding to them.
Director, yes or no? Is yes.
As always, remember to subscribe for more in-depth breakdowns like this one. The exchange began when Congressman Goldman pressed Patel on a simple and direct question, one many Americans have wondered about since the release of the Epstein files, whether Donald Trump appears anywhere in the Epstein-related documents. Patel initially asked the congressman to repeat the question, prompting Goldman to emphasize that the inquiry was straightforward. Patel then responded that the committee had already released all legally releasable references to President Trump, as well as anyone else whose name appears in the files. Here's where the tension escalated. Goldman challenged Patel's explanation and asked what laws he was referencing when he said certain material could not be disclosed. Patel cited multiple court orders, including those related to grand jury secrecy rules known as Rule 6E. Goldman pushed back, asserting that Patel's interpretation was wrong and that certain materials Patel described were not actually restricted under those rules. When Patel suggested there were additional sealed documents and protective orders involved, Goldman countered again, claiming those materials had already been unsealed during discovery in the Ghislaine Maxwell case. This is an important learning moment for viewers. Legal terms like sealed, unsealed, protective orders, and Rule 6E often get thrown around in congressional hearings, but they have very specific meanings. A sealed document is one a court has restricted from public access. A protective order can limit how certain evidence may be used or shared during legal proceedings. Rule 6E strictly governs grand jury material, which by law cannot be publicly released without a judge's approval. These distinctions matter because they determine what a witness like Patel is legally able to disclose, not just what they are willing to disclose. Goldman then confronted Patel on another issue that has long fueled public speculation: the existence of videos and photographs seized during FBI raids on Epstein's properties. Goldman asked whether Patel was refusing to release those materials because of a court order. Patel responded that he never claimed there was a blanket order on the videos, but stated that most of the footage consisted of pornographic content downloaded from the internet and child sexual abuse material that cannot legally be released under any circumstances. This is crucial to understand. Federal law prohibits distribution of child sexual abuse material, even by government agencies, which means vast portions of Epstein-related evidence are legally barred from public release. That reality often collides with public expectations for transparency. But here's the broader takeaway. Appearing in Epstein's files does not automatically imply involvement in wrongdoing. These documents include travel logs, guest lists, contact books, and other records from decades of Epstein's life, many of which involve individuals with no knowledge of or connection to criminal behavior. That context is central to preventing misinformation, especially when discussions involve public figures. What today's hearing really exposed was the ongoing struggle between public demand for transparency and the legal boundaries that restrict what government officials can release. If you're finding this breakdown helpful, make sure you subscribe. We go beyond the surface, helping you understand not just what was said, but what it means. As this story continues to develop, the tension between Congress, the Justice Department, and public expectations will only grow louder. Many Americans want answers, accountability, and clarity, but as today's exchange demonstrated, the path to that transparency is tangled in legal limitations, political friction, and decades of complex litigation. Stay with us as we continue to unpack these moments with clarity and depth, and don't forget to subscribe so you never miss a segment.